Hello, my name is Stewart Elworthy. I'm a lawyer in Greater Vancouver. In this episode, I'm going to be discussing employment law, and I'm going to be discussing the context of the obligations that an employer owes to an employee when they fire them. First general rule is outside of a union context, an employer always has the right to fire an employee. They might need to downsize, they might have their reasons. They don't have any obligation to hire an employee for the rest of their lives. However, when they do let an employee go, they do have an obligation to provide a reasonable notice period so that that employee has some time to hand out some resumes and prepare to try to get another job. Now, if the employer doesn't want to keep that staff member on while they know they're going to be leaving later, they may just want to terminate the employment completely and have them leave right away and not pay them anymore. So that's not even giving them any notice. If that happens, they have an obligation to provide a severance package. And that will allow the employee to have some money to buffer the time when they're trying to find another job. Now, there is another issue, and that is the issue of whether or not the termination is wrongful. If a termination is always wrongful if the employee hasn't done anything wrong to deserve being fired. However, if the employee was really incompetent, had a really bad attitude, and had done something significantly wrong, such as, for example, if they stole from the company, then the employer would be able to fire the employee and pay them no severance package and give them no notice. So often, one of the major contested issues is whether or not the employment was wrongful and whether or not there was a good enough reason to fire that employee that would justify not giving them any notice period. That's my first episode on employment law, and I will have more for the future.